Anybody else have experience with a canine that's not a wolf hybrid, a regular old dog? I said, yes, sir, Mr. I'm sorry, is it Mr. Turner? Yes, sir. What was that experience?
Oh, this has been quite a number of years ago, but I was feeding a neighbor's dog while he was on vacation. It was a Malamute. And I was in the backyard with the dog, and the dog was running loose in its own area. I was playing with the dog, and suddenly, I guess, the dog thought my forearm was a chicken bone. And he took a hold of my right arm and would not let go. He was piercing his skin. And I talked the dog out of it. And he let go, and everything was fine at that point.
Did you sustain any injuries other than maybe
Just puncture wounds. Just some puncture wounds to my forearm.
a Malamute? What breed is that? I've got a picture. That's kind of a, what does it look like, a Malamute?
It's a big dog. Malamute is a big dog, and it's kind of a, best I can describe it, kind of a husky looking dog.
It's a husky looking dog.
Yeah, that along that line.
Anybody else have experience with a canine as far as being attacked or bitten or scared that you were going to be or anything like that? Yes, sir, Mr. Kidder.
It was 45 years ago. I was a kid in the college town, but didn't know inside the way. I was just walking inside.
Anybody else? By show of hands in the jury box, is there anybody that knows a man by the name of Barry Laxton? Anybody? In the jury box, is there anybody that knows a man by the name of Nick King? I say this because these are the two people that state alleges were killed at gunpoint. Nobody in the jury box knows these individuals, is that right? Now, the state will probably only put on 4 witnesses. We anticipate there will be the 2 victims. And briefly, 2 law enforcement officers. Anybody know Detective Richard Nestle of the Tippett County Sheriff's Office? Anybody in the jury's office? Yes, Ms. Davis.
I don't know him well. I met him briefly a couple weeks ago. I came up here with my ex-husband. A man ran my ex-husband over, but that's not too much to explain.
Okay.
But I just met him briefly, and I don't like know him much.
So you met him briefly in a professional capacity a couple of weeks ago.
Right.
Is there anything in that brief encounter that would affect your ability to serve as a juror one way or the other? Anybody else in the jury box? Anybody on the first row know Detective Richard Nestle with the Tippett County Sheriff's Office? Also, it's anticipated that there may be testimony from a Sergeant Daniel Walls with the Tippett County Sheriff's Office. Anybody in the jury box know Sergeant Walls? Yes, Mr. Easel. And what is that nature of that knowledge? You went to school with Daniel Walls. Mr. Wallace does not purport to be a witness to the event. The state alleges that there were only, well, we're going to put on 2 witnesses to the event, Mr. King and Mr. Laxton. So anything that Sergeant Wallace testifies would be as far as gathering evidence and all of the same that sort of thing. By school, you mean high school, grade school? Played football with him? Anything about your being on the football team with Daniel Walls which would affect your ability to do your duty? Anybody else know Daniel Walls? Anybody in the jury box? Anybody in the front row know Sergeant Daniel Walls with Tippett County Sheriff's? I wish I could tell you that this is going to be a brief case. I anticipate it's going to be a brief case as far as what the state puts on. I can't tell you if it's going to last today and tomorrow, but it could. Is there anybody in the jury box that has any kind of pressing personal or medical reason that you cannot devote your full-time attention to a case that goes today and tomorrow? Anybody? You'll be obviously given opportunities to make arrangements as far as phone calls and anybody in the jury box, anybody in the front row have any kind of personal, other than the fact that, and I understand that you may not want to be here today, but maybe the one day. But is there any kind of pressing medical or personal or other reason that you cannot devote your full-time attention to this case? Anybody in front of us? Yes, sir.
Who's going to handle the question?
Your Honor, may I take my laptop over to the podium to set it to reprint? Thank you. Good morning, early afternoon. The prosecution works for the state. The judge works for the state. The police work for the state. This is a business. As the prosecutor alluded to, he's going to tell you things that are not facts, things that are designed by the prosecution office to have you have an illusion or an opinion of something. They may bring in things not under oath, but from behind the bar to make you think something that may not be true. So I would ask that everyone keep an open mind and stay alert and awake and listen intently. And if they allow you to take notes, I don't know if that's allowed, but to keep track of all the inconsistencies that you will hear today and possibly tomorrow. There will be several. You will see videotape. You will hear audio tapes. You will see that in this day and time, that if you stick your head up, speak out, expose corruption in government, government comes after you in a big way. Occasionally we hear of cases in the news media where people are the victims, where they're shot at, where they've done nothing wrong. Where they're done.
The state certainly doesn't mind Mr. Parsons not being trained in the law to have some leeway. We object to his argument before that.
Defendant, acting as his own counsel, can state his theory of the case to the jury and then ask questions with regard to your ability to sit fairly on this type of case.
Yes, Your Honor. I was basically following the lead of the prosecutor. He led his idea of the case, and now I'm leading my idea of the case.
To be clear, I'm overruling his objection, Mr. Parsons. State your theory of the case to the jury if you want to.
Thank you. This is a learning process. And you may ask yourself, why would a person choose to represent himself? Well, there was a time in this country, not too long ago really, where people didn't hire attorneys because we were under common law and people represented themselves because that's what you did. You had the 10 Commandments, which basically, if you understood those, if you followed them, you didn't get in trouble. Things are pretty simple. Now there's rules and regulations for anything. Anything you do nowadays has to have a license, a permit. You cease being a sovereign citizen when everything you do has a permit. And when you speak out about these things, they don't like it because it's a business. And anytime, just for instance, just a little quick history lesson. Everybody knows that marijuana is dangerous and it's outlawed, right? Everybody? Okay. But do you realize it only became a crime to have it when DuPont, who manufactured nylon, got a patent for nylon and wanted to replace the hemp rope. Marijuana is a Mexican term. Hemp is the American name for the plant. Most of the plants have no THC. They're not conducive to hallucinogens, or they're not going to make you high. They're just a wild plant. They grow all over the United States. But people were conditioned to believe that the marijuana plant was dangerous to you, when in fact, this was propaganda put upon the people of this country to demonize a plant that was used for ropes in industry for a long, long time, just so that DuPont could come in and eliminate the competition and have free run of the market for ropes. That's a reality. That's what happened to that plant. Of course, our founding father, George Washington, grew hemp, inherited the farm from his brother, who passed away, and of course, the rest is history. But the fact is that throughout our existence in this country, people have been demonized for political gain, for business gain. And the root of that is money, for the most part, and control and power. And what you will see in the course of these events is that, here again, there's corruption afoot, where people can be falsely accused when they can do everything right, but government will step in and say, no, you can't do that. Even though the Tennessee Code, which is the law of the land, most of you probably studied at Civics 101, you have, what do they teach us, 3 branches of government? Raise your hand if you've ever heard there's 4 branches of government. Anybody in the room heard there's 4 branches of government? Thank you. The way the Constitution is laid out in the state Constitution, which reflects the U.S. Constitution, what you've already been told is not true, and I'll correct the record. You have the executive branch, the president, the governor, the county executive, which I ran for 3 years ago. Does anybody remember me running for county executive? Okay. You have the legislative branch. These are the people that you elect that write the laws that are on the books for us to follow. And if we don't like the laws, we get with them and they change the laws. That happens quite frequently too. Then you have the judicial branch, which when there's been a violation of the law, they're supposed to identify, is this in fact a violation of the law? Now that 4th branch of government, as outlined in the U.S. Constitution and the state Constitution, is the jury. Now you were told that you judge the facts. The Constitution says you judge the facts and the law. That means if you're presented with a law that you don't think fits, that law just doesn't, that alleged crime, that charge, just doesn't fit here. Now the elements may be there, okay? Like the red light cameras they're putting up everywhere. Many states are now taking them down because it's unconstitutional. And in Tennessee, you have a right to record your conversations with anybody that you're having a conversation with. In many states, though, you can't do that. So where does your freedom and liberty go when you can no longer protect yourself from corruption, when it's a violation of the law for you to put up a security system on your house because you might record the crook's voice and then he could turn around and sue you? You've heard of the cases where somebody breaks in your house and you defend yourself and then you get sued. The person gets sued because they beat up the crook. How crazy is that? This case is that case. This is that case where the victims, my wife and me and my dog, were shot at by the, quote, state's witnesses. Off their property, they pursued us, shot at us. The testimony will reveal that this was intentional, with forethought, malice. There was no fear because my dog was nowhere near them. And the fact is that you'll have to decide whether or not you want to believe what they're saying, the illusion that they would like for you to believe, or the facts. And if you listen closely and stick with just the facts, just the evidence, you will hear audio recordings of the event. In my business as an inspector, I carry around a digital voice recorder around my neck because if I'm underneath a house or a commercial building inspecting something and I don't have the ability to type it up on the computer or write it down because it's too small, I turn on that recorder and I start talking. In my line of work, I also have a weapons permit, which I've had for many years. When you go into inner city communities, sometimes you have to be able to...
The same objection, Mr. Parsons, testifying without being sworn in the board dial process.
You have the right to make a brief summary of what you expect the facts to be, your intentions about the case, and then you need to do that, please.
Okay. What you will see today, and possibly tomorrow, are not what the prosecution would like you to believe. What you're going to see, the facts will reveal that my wife and I and my dog were attacked. My dog was brutally murdered. Anybody that owns a pet. Now, if you have your dog outside on a log chain that's this long, you know, that's wrong. But if your dog sleeps at the foot of your bed, you know what it's like. Just a few questions and we'll move along. Is anyone in the jury today related to the witnesses, the prosecution, the alleged victims, the officers? I think that's been covered, but here's an interesting thing in the law. The law says that you have to be at least 6 separations away from the people involved. 6 separations. That means your mother, your father, your brother, your sister, that's the first separation. Your children, first separation. Then your sister's husband, second separation. Your sister's husband's brother, third separation. Your sister's husband's brother's cousin, fourth. You see how far out this goes? Really quick. And there was a board game a few years back, 6 separations from Kevin Bacon, because you could prove that everybody in the world was within 6 separations of Kevin Bacon. Now, if we follow that law, I venture to say that there's probably not anybody here who would qualify to be a juror, because somewhere along the line, we're probably related, somehow or another. If you've got any Irish or Cherokee blood in you, you're probably related to me within 6 separations. And it could go on and on and on. Is it likely that you could identify that separation? No, it's not practical. The key thing is that if you know, honestly, in your heart, that you might have a connection with any of the people involved, these are serious charges. They carry substantial jail time. Depriving someone of their liberty is a very serious thing. To consider that you're putting someone in the jail. Now, it's not up to you to determine how long they're there. That's what the judge will decide, and he'll instruct you on that. And many people have probably been on a jury, probably know that, but some of you may not have been on a jury, and you may not realize that. Some people believe that they'll sentence a person. In Tennessee, the judge does the sentencing. So realize that it's a very important job that you do. Do any of you have any family relations or any close relations to any of the prosecutors or judges involved in the hearing today? No. Has anyone now or ever done work for any municipality, city, county, federal, or state government within the confines of Tipton County? Never worked in any capacity with government in Tipton County? Have a spouse that works for government in Tipton County? No. How many of us have children? And married? Those are important questions because if you've got children, you know how it would feel for somebody to have compassion for their child. That will come up in this trial too. How many consider, and the question's been asked about how many have dogs and pets, how many feel that your dog is a member of the family? Can I ask one of the jurors their name because I may have lost my place? Yes, ma'am.
Laney Davis.
Davis? And just because I asked someone their name, it doesn't mean that I'm singling out that person. I'm trying to determine where I am on my page, because when I laid this out in haste, I didn't get everybody in the same order because we added someone on the back row, and I thought we were going to go 666, and so. How many are afraid of dogs? How many are afraid of little chihuahuas that like to bite? How many people have been bit by a little chihuahua? I have. My hand's way on up there. How many people are afraid of large dogs? Okay, here's a real good question. How many are afraid of wolves? How many people? Is that a yes? Well, you're within 15 miles of... Anyway, never mind. How many people believe that wolves are inherently dangerous to people? How many people know that there's never been a case where a wild wolf has ever killed a human in the United States or Canada? How many people dislike Native Americans? Thank you. I'm 3/4 Cherokee. And I have a little appendage here that is not just for cultural reasons, but I support locks of love, and that's kind of one of my things. How many people think that if you have long hair, you got to be a pothead? I know when I see somebody with long hair, I'm thinking, let me check this guy out first. I do. I stereotype. And I got long hair. It's just, it's human nature. Okay. This is a real good one. Does anybody know what a pertussis or a ptosis is? You're looking at a pertussis, called the lazy eye. It's a congenital birth defect. It's what the Cherokee have in common. You're familiar?
What you call that, Duane syndrome?
The Duane syndrome?
Duane. D-U-A-N-E.
You know more about it than me.
Lazy eye.
They call it a lazy
My
eye.
son has lazy eye.
It's very common in Native American bloodlines. Certain people are predisposed to certain things. This is just one of those common defects. The reason I ask is that a lot of people, when they hear me on my radio show or when I'm talking to them on the phone taking an order for an inspection, they have a perception of me because of my voice and the way I speak and the way I represent myself. But then when they see me in person, they have a different perspective because of the assumption that, okay, what's wrong with this guy? The long hair, the eye, is this guy a pothead or what? So it's just natural perceptions that people, I have it myself. And, it's not the best of things to stereotype, but unfortunately a lot of people do. A lot of people think that if you're clean cut, no facial hair, a suit and tie, you got to be a good upstanding person. How many people think just because you wear a suit and tie, you got to be a good upstanding person? How many people think just because you're the prosecutor or the judge that you always tell the truth? And I don't assume anyone's afraid of Native Americans that they're going to come scalp you and take your children in the middle of the night. How many people understand, not just a belief, but they know that you have an inherent right, recognized in the Constitution as our God-given rights to life, liberty, and pursuit of happiness, which means you have a right to protect your life and your family and your property. Does everybody believe you have a right to protect your life, family, and property? Yeah. If something's attacking you, you actually have a duty in the state of Tennessee in the law. Not only do you have the right to protect yourself, you have a duty and obligation. When the state was founded, the first constitutional references were that the people have the right to enact citizen's arrest. Most people have never heard of citizen's arrest. How many people have ever known a security guard that works out at the mall or on a parking lot or a strip mall or warehouse? Security guards are civilians. Sheriff's deputies are civilians too. But under the law, each of these has the same right to enact a citizen's arrest because the citizen is the first line of defense. Of course, nowadays everybody's conditioned to pick up the phone, call 911. But that's not the law. There's no law that says you have to call 911. And if you live out in the county,
Ladies and gentlemen, you're cautioned that at the conclusion of the case, you have to proceed and charge the law from the court, and that you'll have to follow the charge of the law as given by the court at the conclusion.
in spite of what the judge just said, it doesn't comport with the Constitution of the state. You judge the law as well as the facts. That's what the Constitution says. And if I'm allowed, I will show the statutes to you so you will understand. Most people don't realize that. How many believe that the police always tell the truth? How many have been victims of a crime? I know if you got property left out and it's not locked up, somebody's probably tried to take it. So, has anyone ever been abused or had a family member abused by the police or law enforcement? Have you or a family member ever been falsely accused by the police? How many have taken the swine flu shot? I'm just messing. Some people are required to take shots because of employment. That was just to see if you're... There's a lot of thinking people in this crowd because a lot of people realize the flu's safer than the shot, I think. Just a few more questions. Now, when asked, had any of you read anything in the newspaper about this case, no one raised their hand or nodded. Does anybody read the Covington Leader in Tipton County? Nobody over here reads the... Okay. 3. How many of y'all have the subscription to the Covington Leader? How many read the newspaper, the Covington Leader, back in September of 2007? That would have been where articles related to this case occurred. How about July of 2008? Okay. The commercial appeal during that time, possibly. There was an article in there. Front page on the Covington Leader. My picture, front page. Would-be county executive charged.
The jury is influencing the jury in this matter. Things aren't in evidence.
Objection to be sustained. Go ahead with the question, please.
Does anyone here today know me, Mike Parsons? Has anyone ever heard a radio show on AM 1380 called The Voice of Truth? Has anyone ever heard of AM 1380 radio station out of Millington, Tennessee? Alex Jones, The Power Hour. Okay. How many people voted in the 2006 general election?
Can I object? The next question being who you voted for.
No. I can't ask them who they voted for. I understand that.
I object to the relevance of what happened a year before this election.
Objection to be sustained. Go to another question.
Does anyone on the jury feel like they would have a problem with rendering a fair and impartial decision based on the law that you would determine, as well as the facts that you would determine as outlined in the Constitution? Would any of you have a problem with following the law as outlined in the Constitution, which is the supreme law of the land? Thank you very much.
At this time, we'll have, each side has the right to excuse a limited number of jurors without having a reason. All they have to do is write the name down and turn it in. If your name is called out, you're asked to step around and have a seat in the courtroom. Please don't feel offended. Certainly no offense is intended. It's not a reflection on you either as a potential juror or as a person. Any challenges in writing as to the 13 in the jury box, please.
Mr. Tyndall, Mr. Easley, if you'll step around, please. Ms. Baker, Mr. Melton, if you'll take those two seats, please. Any challenges to the 13 in writing, please? challenges to the 13 in the jury box? Any of the 13 in the jury box?
I initially put one.
Just 13 in the jury box now. Ms. Baker, if you'll step around, please. Mr. Owen, if you'll take that seat, please. Any challenge to any of the 13 in the jury box, please? State, have anything we need to take up with the jury sworn? No. Defendant have anything?
No, Your Honor.
Would stand and raise your right hand, take the oath of the jury, please.
Do each of you solemnly swear or affirm that you will try the issues joined in this case, a true verdict rendered and deliverance made according to law and evidence, so help you God? Please say I do.
I do. Seat, please.
Hey, ladies and gentlemen, remaining jurors, I want to thank you very much for your attendance today. If you need a certificate, please stop by the clerk's office. Call in over the weekend to see about next week's schedule. And again, we can't thank you enough for your willingness to serve as a juror. Thank you very much. You're excused at this time. Thank you. Hey, ladies and gentlemen, we're going to take a break before we go to the next stage of proceedings. During this break, the lunch break, and any other breaks that we have, there are certain rules that I'm required to give you that you're required to follow. First of all, please don't begin discussing the case among yourselves until you've heard all the proof, received the charge of the law, and retire to deliberate. You should not speak with anyone else regarding any subject connected with the trial, nor should you form or express any opinion when the case is finally submitted to you. You will report promptly to the court any incident involving any attempt by any person to improperly influence any member of the jury or a violation by any juror of the court's admonitions. And while it's not likely to occasionally arise, you're not to read or view or listen to any news reports concerning the case. The case has to be decided solely alone on evidence introduced during trial. You swear the officers, please.
Do you as officer solemnly swear that you will take charge of this jury, that you will keep them separate and apart from all other persons during the progress of this trial, that you will not permit them to communicate with any other person or any other person to communicate with them about the case or any other matter unless it be in the presence and in the hearing of the court, and that you will not communicate with them about this case, that you will otherwise discharge the duties imposed upon you as such officer, so help you God. I do.
You can step out to the jury room. The officers will make a telephone available to you if you need to call someone and tell them that you're on the trial, on jury duty for the day. However, please don't discuss anything about the case you may have learned up to this stage, including the names of witnesses, defendant, or anything else about the case with anyone over the telephone. For your planning purposes, the lunch will be provided to you today. The officer will let you know when it's time to come back in the courtroom. You can step out. The room has been called for. If there's anyone in the courtroom that anticipates being a witness either under subpoena or voluntarily, you're asked to remain out of the courtroom until you're called to testify. And after your testimony, please don't discuss your testimony with any of the other witnesses or discuss other witnesses' testimony until the conclusion of the case. Take about just a short break, about a 10-minute break, and then we'll come back to the courtroom. Stand in recess for about 10 minutes.
It's not part of this record either that needs to be transcribed or anything. And it relates to setting the motion for summary judgment in the civil matter. And I thought since Mr. Parsons was here, we could get a date, and that's not part of the motion to quash.
I'm available November, December, January, and then March.
Your Honor, sometime in December would be fine with me.
You have a preference, Mr. Parsons?
Actually, I would object at this point to setting a date for a motion to, I haven't been served yet, so I'm waiting to get these motions before I can respond to them.
But if he hasn't been served, he's entitled to 30 days to respond.
Well, we did serve them, Your Honor, and they've been filed for more than 30 days. We served them by letter to Mr. Parsons. Both the motion for summary judgment was filed October the 12th. The motion was filed October the 12th, 2009. They were sent, when they were filed with the clerk, they were sent to Mr. Mike Parsons at the same time that we sent them to my clients. Everybody that I know has received them, Your Honor. I don't know why Mr. Parsons not received them. We have sent them to the address that is listed upon his complaint that he filed against Deputy Fletcher, and so they have been pending. I have never been informed by Mr. Parsons that he has not received any of our correspondence. We have filed a motion to dismiss also before we filed the motion for summary judgment, but the motion for summary judgment is supported by additional evidence, and therefore we felt like we needed to have that date scheduled.
Did you not receive it, Mr. Parsons?
Your Honor, I've had no conversation, no contact with this office whatsoever, other than I did recently receive a motion of quash, and there was a...
And that's not responsive. Did you receive the motion for summary judgment?
No, sir.
All right. I'll ask you to make a copy and hand deliver it today.
Yes, sir.
I'll set it more than 30 days out. Set it for January 8th.
Excuse me, Your Honor, I'm sorry.
January 8th.
January the 8th.
Yes, sir.
January the 8th to be, I may have to, January the 15th to be better. I may have to take my daughter back to college. January the 15th at what time, Your Honor? 9:30. 9:30? Now, I would point out that if he received the motion to quash, we sent the motion for summary judgment to the same address, but I
Mr.
understand.
Burke, you want to read the indictment?
I'd rather, I can, but Mr. Freeland's on his way back. He went to the he thought it was a month break, John. He said he'd be right back.
I'm sorry, I didn't know we went on break. I guess we can.
I think he got confused. He said he'd be right back.
He's coming in the door now.
There he is right there. Sorry, John.
If the jury's ready, ask him to step in.
Your Honor, may I approach?
Maybe just a minute.
Oh, okay. I'm sorry. Thank you.
Please, thank you.
Okay, ladies and gentlemen, at this time, the state will read the indictment against the defendant. The indictment is a formal written accusation that charges the defendant with commission of criminal offenses. It's not evidence against the defendant. It's not guilty of guilt. The state has the obligation to prove the guilt of any defendant to you beyond a reasonable doubt by calling witnesses and receiving testimony. The indictment is merely a charging document in which the defendant has been proved. You may read the indictment.
State of Tennessee versus Michael W. Parsons, State of Tennessee, Tipton County, Circuit Court of Tipton County, July term 2008. The Rangers of Tipton County, Tennessee, duly and manly sworn upon their oath, present that Michael W. Parsons, on or about September 24, 2007, in Tipton County, Tennessee, and before the finding of this indictment, did unlawfully, feloniously, and knowingly confine Nick King so as to interfere substantially with Nick King's liberty, while he said Michael W. Parsons was in possession of a deadly weapon, to wit, a Glock 9mm handgun, in violation of PtII 39-13-304 against the peace and dignity of the state of Tennessee. The grand jurors on their oath said further presented that Tipton County, on or about September 24, 2007, before the finding of this indictment, said Michael W. Parsons unlawfully, feloniously, and knowingly confined Barry Laxton so as to interfere substantially with Barry Laxton's liberty, while he, the said Michael W. Parsons, was in possession of a deadly weapon, to wit, a Glock 9mm handgun, in violation of PCA 39-13-304, against the peace and dignity of the state of Tennessee. Now, 3, the grand jurors on the oath said further presented in Tipton County on or about September 24, 2007, before the finding of this indictment, said Michael W. Parsons did unlawfully, feloniously, and knowingly by the display of a deadly weapon caused Nick King to reasonably fear imminent bodily injury by pointing a gun at him and forcing him to get down on his knees, in violation of TCA 39-13-102, against the peace and dignity of the state of Tennessee. Count 4. The grand jurors on their oath said further in Tipton County on or about September 24, 2007, before the finding of this indictment, said Michael W. Parsons did unlawfully, feloniously, and knowingly by the display of a deadly weapon caused Barry Laxton to reasonably fear imminent bodily injury by pointing a gun at him and forcing him to get down on his knees, in violation of PCA 39-13-102, against the peace and dignity of the state of Tennessee. Count 5, the grand jurors on their oath said further present that in Tipton County on or about September 24, 2007, before the finding of this indictment, said Michael W. Parsons did unlawfully, feloniously, and knowingly entered the 2001 Chevrolet pickup truck of Nick King without his expected consent with the intent to commit theft in violation of TCA 39-14-402 against the peace and dignity of the state of Tennessee. Count 6. The grand jurors on their oath of office they further presented to Tiffin County on about September 24, 2007, before the finding of this indictment. It said Michael W. Parsons did unlawfully, feloniously, and knowingly obtain property to wit a black leather padded holster. The more particular description thereof leaves the grand jurors unknown. Valued at $500 or less of Nick King without his effective consent. With the intent to surprise said Nick King, in violation of Tennessee Code Annotated 39-14-103 against the city's executive of the state of Tennessee. Count 7. The grand jurors on the oath of office had further presented to Tiffin County on about September 24, 2007, for the finding of this indictment. It said Michael W. Parsons did unlawfully, wrongfully, and knowingly obtain property to wit a Ruger 10-22 rifle. The more particular description thereof leaves the grand jurors unknown. Valued at $500 or less. Barry Laxton without his effective consent. With the intent to defraud said Barry Laxton in violation of PtII 39-14-103 against the peace and dignity of the state of Tennessee. D. Michael Donovan, District Attorney General.
To the charges contained in the indictment, have us attended, please.
Not guilty to all charges.
Hey, ladies and gentlemen, we're going to take a break for lunch. During this break, I ask you to remember the things we've been over, that is, please do not discuss the case among yourselves, allow anyone to discuss it in your presence. After lunch, when you come back in, you'll hear the opening statements, then you'll begin to hear the proof of the case. Hope you have a good lunch, and the bailiff will let you know when it's time to come back in. You can step out.
Before we recess, I think there are a couple of things that probably need to take place. One is, during the break, I have seen a copy of what appears to be a civil suit filed by the defendant in this case, the United States District Court in the Western District of Tennessee. A copy of which has been filed in this file. That is in the case of State of Tennessee versus Mike Parsons, document 6030 here in this court. I want to state on the record that this will not prevent the court from being fair and impartial during the course of this criminal trial, that it won't have any bearing on holding for the defendant or against the defendant or for the state or against the state. That it's certainly not, as far as I'm concerned, a cause for recusal or a continuance. Also, the clerk gave me a copy. I can see the file back, please. For the benefit of the record, during the break, I was presented a copy of an order from the Court of Criminal Appeals in this matter, denying the defendant's application for extraordinary appeal and stay of the lower court's proceedings, which was apparently filed in the appellate court yesterday. So I know the defendant had alluded to that earlier before in the first part of the proceedings, and I indicated that I would certainly, if I was stated by the appellate court, certainly cease the proceedings. So the appellate court has denied his request for relief. See, Mr. Pentecost, you had indicated also that you had a matter you wanted to take up in this matter.
Yes, sir, Your Honor.
Let me state what your matter is. Let me see if it's an appropriate time to
Your Honor, my matter relates to a motion to quash filed on behalf of Deputy Jeff Fletcher. That matter was filed with the clerk on November the 16th of 2009. Notice of hearing also set forth the hearing to be today at noon. I'm representing Mr. Fletcher, Deputy Fletcher, as it relates to an unrelated civil matter.
If you'll state the basis, please.
The basis, Your Honor, relates to the summons that was served upon Mr. Fletcher, Deputy Fletcher. It asks specifically that was served upon him on November the 9th of 2009. It says, bring with you the videotape of the assault of Mike Parsons by Jeff Fletcher. First of all, Your Honor, as it relates to why I filed the motion to quash, is based upon my representation of Deputy Fletcher in the civil matter that has been brought by Mr. Parsons, which is docket number in the civil court 6600. I would also state that I am providing to Mr. Parsons at this immediate time a copy as instructed by the court concerning that civil matter, and I motion for summary judgment. Your Honor, we filed this motion to simply put the court on notice that, first of all, there is no videotape that exists concerning any assault that was upon Mike Parsons by Jeff Fletcher. Out of respect for the court, there's no reason for a witness to be called and then state that I have no video of any assault upon Mr. Parsons by Deputy Fletcher. Second reason, Your Honor, is that if Mr. Parsons is referring to the videotape that exists concerning the arrest of Mr. Parsons pursuant to the capias that was issued in this case in the criminal matter, then, Your Honor, that video, I thought, had already been provided to Mr. Parsons, but since he said that he didn't get our correspondence, I don't have a copy of that video available to me to give to him today, but yet that video is filed in the civil matter with the clerk's office as part of our motion for summary judgment in the civil matter. The third thing, Your Honor, is that Mr. Fletcher, Deputy Fletcher, is not the custodian of that videotape, but yet, Your Honor, another subpoena was issued, which I received yesterday, which is to the custodian of the records of the Tipton County Sheriff's Department, which again asked for them to bring with you the video of the assault of Jeff Fletcher on Mike Parsons. And, Your Honor, again, I would object to that, or ask for that subpoena to be quashed based upon the same grounds, Your Honor. And that is why I do not believe that we can produce, that Deputy Fletcher, nor can the sheriff produce any video of any assault upon Mr. Parsons, because simply it didn't occur.
What you indicated that there was a incident between your client and the plaintiff in the civil case, Mr. Parsons, defendant in this case, with regard to his arrest. When was that incident?
That incident occurred, Your Honor, on or about July the 8th of 2008, which was the date of the issuance of the capias pursuant to the grand jury that was presented to Deputy Fletcher, and Mr. Parsons was here at the courthouse and he was arrested. That videotape is dated that same day, I do believe, Your Honor. Let me get to the affidavit of Mr. Fletcher that was filed in support of the motion for summary judgment, and it gives the specific date on July 8th of 2008. Yes, sir.
Yes, sir.
get a response.
Yes, sir.
Excuse me.
Counsel is asking that the matter be quashed because he claims he doesn't have his client doesn't have custodial control or access to the video.